I'm Shelley Kierstead, delighted to welcome you to this panel on community legal education, A2J programs, and intervention tools. So exciting. We have a panel of folks from Canada, US, Australia, so we've got a nice geographic span today. I'm going to just introduce our speakers briefly in the order in which you'll hear from them today. But we decided not to make it too straightforward. It's not the order in which they're seated, so gotta keep you on your toes. Belinda Lowe is the principal lawyer of Eastern Community Legal Centre in metropolitan Melbourne. The centre is a multidisciplinary legal service that works to prevent problems, progress fair outcomes, and support the well-being and resilience of communities and community members in Melbourne's East. Belinda has more than 20 years' experience in the legal sector. So thank you, Belinda. Kate Fischer Doherty is the Director of Clinics at Melbourne Law School. In this role, she oversees a suite of 7 law clinics, maybe just a little busy, huh? And an extensive public interest legal internship program for which she is the subject coordinator. She's designed and co-designed several new clinics, including street law, community legal empowerment, and Indigenous legal advocacy clinic, which sounds super interesting. Rebecca Robichaud is Director of Experiential Education and Pro Bono Initiatives and an Assistant Clinical Professor at Wayne State University. And prior to her current appointment, she served as the Director of Externships. She co-founded the Warrior Housing Corps in response to the U.S. Attorney General's call for law schools to engage in addressing the eviction crisis in the U.S. And she's taught a community advocacy clinic for several terms. Turning to our next Rebecca, Rebecca Sandefur is a professor in and director of the Sanford School of Social and Family Dynamics at Arizona State University. She investigates access to justice from every angle, from how legal services are delivered and consumed through many other channels, through to how ordinary people think about their justice problems and try to resolve them. Rebecca is also a faculty fellow at the American Bar Foundation, where she founded and leads the Access to Justice Research Initiative. And Julie Mathews. Julie, from 2000 to early 2023, served as an executive director of Community Legal Education Ontario, or CLEO, as we fondly refer to it, an Ontario-based community legal clinic that specializes in public legal education and information. And during her last years at CLEO, Julie began to conduct research with Professor David Weissman at University of Ottawa Faculty of Law on the role of community workers in supporting people with law-related problems. Julie and David have produced several reports on this topic and continue to work in this research area. So needless to say, I think we've got a fantastic group ready to share some of the work that they've been doing with you. So the way that we've kind of structured this presentation is that each of our speakers will speak for 9 minutes, well, 9 to 10. And then we will open the floor so that we can hopefully get lots of dialogue going. So I am going to, with that, turn the floor over to Belinda.
Hi, everybody. It's not at all intimidating to be on a panel with these super smart people to my right. I just felt the need to articulate what is clearly untrue. First thing, but I did want to start by thanking the Osgoode Hall Law School and the Victorian Law Foundation in Melbourne, Australia so much for supporting us being here today, and it's an absolute delight to be here with all of you. So the presentation I'll be speaking to today will highlight the critical role of proactive and evidence-based intake processes in improving access to legal services, particularly for marginalised individuals, by utilising data collection and sentiment analysis to better understand and address diverse legal needs and barriers. Before I start, I'd like to acknowledge that our presence here today is on the traditional territory of many Indigenous nations who are listed here. And also I'd like to acknowledge that the legal centre that I come from works on also First Nations land that is also listed here. So just a little bit about the legal centre that I come from. I come from Eastern Community Legal Centre. We acronym it to ECLC, and you can see that we're located in Victoria, which is in the southeastern corner of Australia. And ECLC in particular is located in the capital city of Melbourne and covers what we say is 6 local government areas. It's quite a large catchment in Victoria, and the population is about 1 million people. Eastern Community Legal Centre's vision is human rights, fairness and justice. As Shelley enunciated earlier, we are a multidisciplinary service. We prioritise 9 communities that you can see listed here. We provide legal advice, representation, community legal education, community engagement, referral, information and strategic advocacy services. We're funded through all levels of government, that is federal, state and local government, and we also receive philanthropic support. ECLC's work on legal capability and data is supported through 3 strategic pillars. You can see them here on the slide under our commitment to person-centred practice. That is making service pathways easier to find, evaluating services and promoting multidisciplinary and integrated practice. Now, before we get into things, I'd just like to take a moment to provide some brief context and background to the work in this space, and particularly the frameworks, research and understandings that guide our approach. So the first thing that ECLC needed to understand is how intersectionality impacts on obtaining equitable legal outcomes. When individuals have insufficient capability to self-help, they can often face challenges in navigating complex systems to get the help that they need. I think that's completely understandable. So it's important to understand that when developing and providing legal assistance services that are person-centred, we need to have an intersectionality lens in our approach to providing the required legal support and assistance. ECLC's enhanced intake and legal capability assessment is informed by intersectional framework approaches that are holistic. Individuals that experience inequality often experience compounding challenges. Their problems tend to last longer, and they're often further complicated if they experience multiple intersectional factors. Inequality to legal capability is central to the gap in justice. How well someone can access legal support is closely related to what they can achieve. To meet people's needs and resolve issues fairly, we need to recognise and address different levels of legal capability. Oops, excuse me. All right. Legal issues often exacerbate as existing social and financial challenges faced by individuals, creating confusion about where to seek help. Struggling to prioritise which problem to address first, it can be increasingly difficult to access the necessary support and resources to resolve legal matters. So, an holistic approach to clustered legal problems helps individuals address multiple issues at once, leading to better outcomes by recognising how legal and socio-economic factors are connected, thus providing support for better navigation of the legal system and overall well-being. This is also evidenced in our data, which you can see here, that people accessing our service will on average present with at least 2 intersectional factors, which may affect their ability to successfully navigate and access legal help they need. I'll go into this a bit further later. We also recognise that barriers to access also exist in our organisations, our systems and our processes, and legal problems tend to cluster. The experience of multiple legal problems is common, and if you have one, you're essentially likely to have more than one, with those legal issues compounding with other social or financial challenges, making it even harder for people to know where to get help and which problem to deal with first. So, the Legal Centre needed to ensure that our legal assistance approach met those challenges. or continue to meet those challenges. So at ECLC, our person-centred approach, particularly at the initial point of engagement with our service, is to meet people where they're at. So as recently highlighted in the Victoria Law Foundation's Public Understanding of the Law Survey, Volume 3, inequality of legal capability is right at the heart of the inequality of justice. If you want to meet legal needs and resolve problems, you need to understand and respond to diverse capabilities. Individuals with lower skill levels, less confidence and negative attitudes towards law and lawyers are less able to resolve problems independently, more challenged in obtaining necessary support, and less likely to achieve satisfactory outcomes. So unfortunately, their legal problems are likely to last longer. Understanding individuals' legal capability, particularly in relation to their legal knowledge, ability to self-help, psychological well-being and willingness to seek help is important to elicit the right information to ensure that the service provided meets their needs. Otherwise, I think completely understandably, they're likely to disengage or the service may be unable to meet what it is that they've come in to seek help for in the first place. So this approach helps us find the right balance in service provision between underserved and overserved communities. The approach focuses on working with people's strengths and understanding their challenges to identify legal capability and support them into the most appropriate support for their needs. It also helps our organisation to plan for appropriate resource allocation as well. This slide here shows the principles that ECLC adheres to in our intake process. So the ECLC Enhanced Intake and Triage approach is premised on a no wrong number, no wrong door service model. It's person-centred, trauma-informed and multidisciplinary in practice. Recognising, as mentioned earlier, that people experiencing complex life challenges face many barriers. So, in these times of change, asking the right questions periodically is critical. That's something that we've noticed. And of course, the questions that we ask will ultimately produce the answers that we will get. ECLC's journey into understanding data insights has been about uncovering the stories that lie beneath the surface. We constantly reflect on why we do what we do to really understand the profound consequences of not doing what we do. This means asking the following questions. Who are our clients and what are their intricacies and their needs? What barriers stand in their way when they seek legal help? And most importantly, how effective are our services in meeting these critical needs? We collect data along the person's journey when engaging our service to obtain meaningful data sets that help inform how we're meeting legal help seeking needs and to try and really understand, does the what we provide work that helps inform continuous improvement? This slide illustrates the data we collect along a person's journey with ECLC, which helps to not only just gather relevant data, but actually to apply insights to target the right communities so we are not over-servicing and also meeting current and emerging people's needs. By focusing on relevant metrics, we can enhance the overall quality and effectiveness of legal assistance services, ultimately leading to better outcomes for individuals and clients. This also helped us inform resource planning and service design and strengthening our capability assessment at the critical front entry point. Now, this is just a few examples of how we collect and use the data to inform resourcing and service provision. And this graph shows the multiple intersectional factors that our clients present with and the complexities of service provision for priority groups. You actually can get a copy of these slides that I'm totally whizzing through very quickly, just really fast. And this graph shows different types of people getting different types of services. And so you can see here, based on an individual's capability assessment, people with little to no intersecting factors and strong capability to manage their legal problems are provided with referrals. And across the centre, we are now seeing an increasing trend in people with multiple intersectional factors, that is 2 to 3 intersectional factors who have more disadvantage and less capability to self-help, and they're provided with more complex legal advice services. This is a slide that has shown the key changes that we have implemented. Please feel free to scan the QR code there. That will tell you more about our enhanced entry and triage program. And this slide shows our key focus areas as part of our commitment to continuous improvement. I have really whizzed through this, and I hope that your ears are not ringing from how quickly I've been speaking. But I think it's time for me to hand over to Kate. So thank you very much.
Great, thanks Bea. Thank you, Shelley, for the introduction, and thank you all for coming to this session. One thing that is quite nice about just having the two parallel sessions is that we get to share experiences with sort of quite a larger group than sometimes happens when there are lots of parallel sessions. And I echo Belinda's comments about the honour of being on a panel here and having so many people with so much knowledge in the room. My name is Kate Fischer Doherty. I'm the Director of the Clinics Program at Melbourne Law School. Thankfully, Belinda was thoughtful enough to include a diagram of Australia showing where Melbourne lies. So I am very grateful for that because I'm there as well. And in fact, as you'll see, as I talk about the project that I ran, Eastern Community Legal Centre was one of our key partners in that project. And you can see what a thoughtful collaboration that was. So today I wanted to give an overview of a community legal education subject that I developed last year at Melbourne Law School as part of our clinical legal education program. And I recognise that in the Canadian context we have slightly different terminology, so apologies if there's any confusion. We refer to community legal education, which is also known as public legal education. Clinics in Australia generally refers to clinics located within law schools. So rather than what we would call community legal centres like ECLC, though obviously there's some overlap there. I'm going to give a fairly high level overview, hopefully taking Trevor at his word to keep it short. So, that working? No, skipped too many. Okay, you can see there the entrance to the Melbourne Law School Clinics space. I also extend my respect to the many landowners of the Toronto region and pay my respects to any First Nations people with us today. So, the project that I ran was a community legal education law student clinic, and it had a couple of key aims. The first one was to provide students with a richer and more nuanced understanding of the ways in which we can think about access to justice and interventions to assist particularly marginalised and vulnerable communities. And I put up there my favourite diagram of my tradie with his toolbox. Many of you would be familiar with the saying that to a carpenter everything looks like a nail. To a law student everything can look like, understandably, given that they are reared on a diet of case law, particularly appellate decisions, everything can look like a one-to-one legal advice, generally in the courts and generally in the High Court. And in fact, we know that that's not where most justice happens. And I was really pleased to hear the Chief Justice talk about legal empowerment and legal education and civics education. I have a diagram up there that comes from material on the Sustainable Development Goals for Inclusive Growth, Goal 16 about access to justice, promoting the rule of law at national and international levels, ensuring equal justice to all. And in fact, you have many stages of providing access to justice that happen way before you get to advice and representation. There's another diagram that I didn't include in the slide today, which is of the iceberg. We see the top of the iceberg, which is robed barristers at court, but in fact lots is happening under the water. So I wanted to deepen students' understanding of that. The second key aim was to provide tangible support to community legal centres by way of students working on real projects that were identified as important by those centres. It's a very sensitive clicker. Oh, back again. I wanted to do it on a partnership basis. It may be that we could have done some of these projects independently, but I particularly wanted to work in partnership, not only because there is a lot of thoughtful and innovative work being done in the community legal sector, but also it was an opportunity for students to see how the pieces fit together. And learn by interacting and working with the lawyers and the CLE workers at those particular centres. So developing good partnerships was key to the project. I've put up there a bit of a timeline of my process. It took, probably about 8 months to develop and I guess massage in some cases the projects into something that would work for a student law clinic. I connected with a very active group that we have in the Victorian community justice sector, which is the snappily the CDCLEWG, and presented to them about what I was proposing. I asked for expressions of interest, not knowing what would come in, and was in fact overwhelmed by really wonderful and high quality projects that I've listed up there. As you can see, they cover a diverse range of areas of law and types of resources that the organisations were looking for. We did 2 partnerships with Eastern. They were a wonderful partner, and hopefully perhaps in the question time I can get some of the feedback from Bea on what she thought. All of the projects, with the exception of the final one, were with community legal centres or law clinics. The final one was a really interesting one. It was actually a health program that worked to support people with an intellectual disability, the AH standard for accessing health. And that project was to design and develop a resource to provide discrimination law information for healthcare providers. So a really different, I've only got 2 minutes to go. Okay, really interesting projects. So our starting points were, I was fortunate that the clinic was being run at just about the same time as volume 1 of the Pulse was released. And so we drew very much on the research contained there about legal capability. Belinda talked about that. Many of you would be very familiar with the Pulse report and the research and evidence on legal capability. I was very fortunate to have Hugh McDonald come to talk to the class. So, they didn't need it to hear it from me. They heard it from the expert. We used a legal design approach. I wanted them to build, it was a law school clinic, I wanted them to build skills of creativity, to thinking about the client, the starting point of who is your client, what's the purpose of the CLEI, is it self-help? We want to allow people to solve their problems themselves, or is it wayfinding? We want to direct them to services. So really getting to that client-centred perspective. Ooh. So here, I won't talk these through. These are just some of the resources the students prepared as a result of the projects. That was the consent project. That was a little a sort of wallet-sized card, trifold that folded up about consent, cybercrimes and the law. This was the Climate Justice Project, where students actually worked on insurance-related resources, which was not what the students had expected climate justice to be about, but was actually the need identified by the centre. This is a lovely photo of my students together with the 2 CLE lawyers at Eastern, my consent group delivering their project. So all of the groups did a presentation to the centre of their project, and they were very pleased with themselves for that. Feedback on the project was positive. That's some of the feedback from the Climate Justice project at Eastern. And I believe that the students developed various social media resources and they were used when the next disaster came. This is some feedback from a student who worked on the Q Plus law, which is an LGBTI plus legal service at Fitzroy Legal Service in Melbourne. And I think this sort of resonated with some of the things the Chief Justice was saying this morning. So, wrapping up, the project was successful in many ways. One of the things students really liked was the partnership with the lawyers in the service, getting to see what community lawyers did and how legal information fit within a broader framework. I would say that the key factors for any project like this one are relationships. You need to invest in developing relationships and strong relationships, and you need to have clear and shared goals and spend time ensuring that you have clarity in the project scope and anticipated outcomes. I'll be running it again next year. If there are any Australians in the audience and you would like to partner, please just let me know. But otherwise, that's it, and thank you.
Okay, so I'm Rebecca Robichaud. I'm going to skip through the gratitudes and the acknowledgements in an effort to stay on track, and because my colleagues did such a wonderful job. But I'm thrilled that we have so many people here. The reason just to give you a little bit of an explanation about why I wanted to present on this program is I'm new to this forum and like this space. And I think our program that the navigators I'm about to describe, I know a lot of people are doing navigators and similar things with community justice workers, but I think we're the only one in the US housed in a law school. I'm not sure if that's 100% true, but I'm hoping that people here that are doing similar programs, we have opportunities to chat about some of the way things are working. So I'm talking about our expungement navigators program at Wayne State. Wayne State is located in Detroit. What I'm going to cover is why we did expungement, how we involved legal navigators, and what my definition of legal navigator is, and then evaluate the organization, the training we did, and talk about what's next. So sort of key to all of this are keeping, at least for us when we were developing this, we're keeping in mind what are the collateral consequences of a criminal conviction, because that sort of drove the why expungement. And then where do you go to get help if you're trying to get your record expunged? Because that also drove how we did our work a little bit. And so the why expungement, for those that in the US obviously, but expungement is when a record of criminal conviction is sealed or destroyed. And so what we found is that well, we didn't find, it's common knowledge, I think, at this point, is that when people have a criminal conviction, it impacts not only the criminal record, but it can impact their ability to get housing. It can impact their ability to get benefits, government benefits of different kinds. It can definitely impact employment. There's studies that show if you have criminal convictions, you will make significantly less over your lifetime. It can impact child custody issues, a variety of things. It can also deeply impact your emotional and mental and physical well-being. I give an example that one of the first gentlemen that we helped through our program was over 80 years old. He had one conviction for a concealed weapon. He lived in Detroit during a very violent time in the city, so it was, I think it was pretty common for people to carry weapons, unfortunately. And he was sort of targeted by police. He came out of his factory job and they would sort of wait for people to come out of those and find reasons to pull them over. He'd had this conviction for decades and he came to us to get help. We were able to help him and go to the hearing. There were really no issues. It was because it had been so long and it was his only interaction with the criminal justice system or criminal system. But when he received that, the judge ordered the expungement, he started crying because of the relief of not having to carry around this label of being a criminal and having a criminal conviction, because it was so important to him not to carry that label anymore. So I bring that up because when we talk about collateral consequences, we focus on these very tangible things, but there's a lot of intangible consequences too, in the sense of like mental, emotional health. So in Michigan, in 2023, I don't have the conviction rates, but I can tell you that we had over 65,000 felony charges filed and 120,000 misdemeanor charges. So you can imagine that with that many being charged, we have well over 100,000 people or 100,000 convictions in the state each year, roughly. Why the need is so great for expungement assistance. And it just continues, right? It's not abating, unfortunately. So in Michigan, in 2021, our legislature and governor passed what are called our clean slate laws, which actually expanded who would have access to expungement, which type of criminal convictions, how many. And so it made it broader and more people became eligible. So again, the combination of all those factors drove why we got into this particular space. The expungement process, which I'll be brief, the way it works in Michigan is first you have to determine if you're eligible. You do that by printing a thing called the ICHAT, which lists out what your convictions are. And then you have to go to your court or courts where you were convicted, get a certified court record, and then you have to fill out this application. You have to get it notarized. You have to get fingerprints. You have to pay a fee. You have to mail this packet with varying things in each mailing to 5 different offices. So when our Attorney General's office says, this is an easy process, we've simplified it for everybody. And I'm like, I can't even help some of my students understand this sometimes, right? So we realized that it is, for those that practice in legal systems, it is straightforward. It is fairly easy relative to a lot of other processes and issues that we deal with, but it wasn't for our community members. And so again, it really offered a space where we could make some significant strides for our community members, but engage undergrad and JD students, and it was in not this overly complex area of law. And unlike, for example, immigration, which was where I practiced for a long time, these cases last like 6 months instead of like 20 years. So it meant that a student could start and see it through, which is really helpful. So I'm not really going to talk so much about the JD aspect, the lawyer aspect, because I really want to focus this on the navigators. So our JD students and volunteer pro bono lawyers handled the things that only lawyers could do. But what we wanted to do is develop this program of navigators that would support and free them up to do the things that only lawyers could do. And so at Wayne, roughly 2 years ago, we started an undergrad in law program. And it is robust, and the students are so excited. They want to learn about law, learn about opportunities to be in law, whether as a lawyer or otherwise, and they want to do practical work. So we had this very robust human resource that we don't have in our JD program, and we had this robust community need in the expungement space. So that's how we came about with our navigators. So for our navigators, they're undergrad students. The way it was, and I'll get to how we're changing it, students volunteered. It was purely volunteer, no credit, no pay, nothing. The undergrad students volunteered. You were a navigator if you were an undergrad, not a lawyer, that you took our training, and you committed to walking with a community member or members through the entire process. So that's how we basically defined navigator. Our goals for those students were to learn the expungement process so they could help our community members through it, to learn how to work with community members, communicate with community members. Oh my gosh, 2 minutes, whoa. And engage with the legal system and explore options in the legal field. And then for our community members, the short of it is we wanted to help them through the expungement process in a way that was made the system less overwhelming and intimidating. And for people who've already been in the criminal system, they want as little interaction with legal systems as possible for understandable reasons. For our navigators, then, what we did is we did 4 videos because we wanted them to be able to watch and rewatch them about core things we wanted them to know. And then we did an in-person training. So the 4 videos covered an introduction to what the program was, what they were expected to do, ethics, and so specifically like you can't practice law and what does that mean? And then communication, how to work with community members. Some of the challenges we had were that, again, because it was volunteer, we really tried to be conscious of how many hours of training we did. And I think that hurt us a little. We could have had more robust training, particularly around working with community members. I realized that the certified court records issue was a bigger issue than I had anticipated, and helping people understand what that is, how to read legal documents and how to organize. So we had our fair. It was a massive success. I hoped 50 people would show up, and we had over 265 people that we helped because the need is so great. The timing, I realized we have to have the fair and then have the navigators program start immediately afterwards, because we had had the fair in November. We had a huge break, and that caused issues with contact with community members. So we've changed all that. We're having the fair in January, and we're now going to offer this not as a volunteer opportunity, but a class. So they're going to be trained as navigators and receive credit. We can ask more hours from them on a very specific schedule, and then have more defined expectations for them. And so we're going to try that out this year. And then the other thing I just wanted to say is we are housing this in the law school because for us it makes a lot of sense, because we do have this robust undergrad law program who really wants to engage, and then this community need. And our hope long term is to grow from doing expungement work to being in the housing sphere and other civil legal areas where our students can be helpful. So thank you.
I'm going to take this from the floor. I want to echo the thanks of my co-panelists, to the organizers, and to everybody who made it possible for us to be here. And I know that Matthew Burnett and I are both very grateful for the opportunity to share this relatively early work and to get your reactions and your feedback. To get us started and to keep us on those 9 minutes, here we go. We know from 2 decades of legal needs surveys that in any jurisdiction where you do these things, many or most of the justice issues that people experience do not get just solutions. And this is a state of estrangement from your own law. And our point, what we're trying to work on here, is that it's not just that you don't get a service or that policies don't have their intended effect, but that this is actually a failure of democracy. So how can we think about access to justice and justice work as ways of rebuilding or strengthening democracy? There. So first, we try to think about how access to justice is a tool for democratization. One thing is that it is a form of civic participation, so you're engaging with your law and your rights, and it also can further civic participation or further your future engagement with your law and your rights. Being able to use these things and have success with them affects your ability to resolve your ordinary problems, to engage with government, to start to demand change of different types when things don't work as you think they should, and therefore to hold institutions accountable. We think that access to justice achieves some of its democratizing power by changing people's relationship to law. So there's lots and lots of work, and I'm guilty of creating some of it, that shows us how discouraging and demoralizing and alienating trying to use justice systems and effectuate rights can be. But there's actually a body of work that shows how this can be empowering and enlightening and make people and communities feel like they are capable of holding their institutions to account. So there is possibility here as well as challenge. And we also would argue that access to justice is a route to democratization because it helps. So the Chief Justice talked a lot about the importance of institutions and trust in institutions. And so one way to build trust in institutions, we have to have them. I mean, in my country, they suck. I imagine in yours, they're not very effective either. But if you have big, complex, diverse societies, this is the way we do things. We can't do it without them. And if people don't trust them, they don't engage with them, they don't comply with the things that institutions ask them to do, and then the institutions are completely ineffective. So if we can use justice work and access to justice to strengthen institutions by making them better, but also more trustworthy, that's in the service of democracy. Now, of course, there are barriers to getting that to happen, and we're particularly thinking about 3 right now. So one is regulatory capture. If you need some kind of expertise or authorization to use your own law, and your society allows a single group of people to control what that means and who gets to do it, you will create a bottleneck of access to law. Justice is everybody's, but bar associations and Supreme Courts in many jurisdictions, including mine, tend to control it. So a first barrier to dismantle is unauthorized practice of law restrictions. A second issue that you run into that's a barrier to democratic engagement is something that Pamela Hurd and Daniel Moynihan, in a stream of work that they themselves do, but that they're also sort of organizing other people to do, call administrative burden. So it's often tempting to feel like the life around us is natural, but it's not. We made it up. So institutions are the way they are because we let them be that way or made them be that way. And so the exercise of many rights and entitlements gets blocked by the poor design or the poor execution of those institutions. For example, when you place the burden on an eligible person to show eligibility, as opposed to placing the burden on a big government with lots of resources to establish eligibility, right? So an important task, if that's a problem with institutions, becomes either reducing administrative burdens or shifting them. And justice workers can be a way of doing that. And then finally, in addition to being difficult to work with, institutions fail in other ways. And if there are key means through which people can access and use law, those failures become very consequential. So one thing is that institutions create bad experiences that frustrate people and discourage them from engaging. And sometimes those are really simple, like rude staff and long wait times. And sometimes they're more complex and intentional, like let's create an eligibility establishment process that is so complicated that no one can make it through. And then we don't have to spend that money. How efficient is that? That frustrates not just the people who have to deal with the institution, but that institution is there to achieve some kinds of policy goals. It can't do them if people can't engage with it to do the things that it's supposed to do. So you create this very bad feedback cycle that undermines the institution. Institutions also fail in another way, which is they operate in their own little world, dealing with problems as they are defined within the context of an institution. And it's not their fault. That's how institutions roll. That's the way they work. But people's actual problems and experiences spread across them, spread across domains of life, spread across different law areas. So if you have to segment your life to meet with these different agencies, that's not a people-centered experience. And it's an experience that creates unnecessary friction if we could get institutions to coordinate with each other. And so getting institutions to work is something that we think justice workers can help with as well. So having identified a lot of problems, then we want to think about how this particular thing can be a toolkit, or it can be a tool in the toolkit of solutions. So the first thing is this idea of justice workers. So we could imagine justice workers being anybody who helps anyone access justice, and then lawyers could be justice workers too, and that would be fine with me. But what we're talking about in this particular paper is community members who assist people in accessing their rights by helping them understand what those are, use the routes to using those rights, and then shape the laws so that they're more responsive to what people understand to be their own needs. And they can do this in formal roles that they already have. So religious leaders, teachers, librarians, healthcare providers, or they can do it as your neighbor, right? It doesn't have to be formalized in that sense. And our hypothesis is that this way of helping people access to justice is particularly effective, or can be particularly effective, because it embodies the 4 T's. So it's timely. These people are already there next to you, so when you need help, you don't have to go find them. It is trustworthy because they are of your community, so they're linguistically competent and culturally competent with respect to what you need. They're targeted, so it can assist people with problems as they experience them in their lives, where they find them, say, in the doctor's office or at the DMV or all these other places. And then finally, if you can dismantle UPL, you can make them transparent. So you can empower people to explain what will happen if you do X or Y, and really help people understand what their choices are and have some autonomy and agency of choice. Unauthorized practice of law. It's an American thing. I'm sure you have some too, though. Everybody, well, not everybody, almost everybody. The model that underlies this is, often when we think about service delivery, we think about, can we do this effectively? Can we scale it up? Can we make this sustainable? Can we make it efficient? And those are all important things. The theory of justice work that we are working about with justice work as democracy work is that these workers are not just helping you solve your problem, which could be attaching to benefits or avoiding eviction, but when this works, it changes your relationship to the law. So you become a person who feels like this institution is accountable to you and will act when you ask it to. If that happens, that's legal empowerment in action. So it's very connected to theories of legal empowerment. And then finally, of course, obviously we're in a moment of new urgency. So democracy is back on its heels in most places. And justice work, at least as it's developing in the United States, is distributed. So no one entity and no one agency controls it. Its energy is located in civil society. So that means you got to find funding for it, and you got to staff it, and you have to change the rules, and that's a hustle. But it also means once it's established, its vitality is independent of failing states, which I think is a really interesting hope at this particular moment. So our point, which I've now tried to tell you in 9 minutes, and as I said, this is very early, and so we welcome all of your feedback. This is why we think that justice work is democracy work. It engages people with law in ways that underline and make real the idea that those laws are their laws, and it engages them where they already are, around the issues they actually have, and when they're successful, they don't just solve their problems, it changes the perception that people have of their own entitlements and their own capability to act. Thank you.
Okay, so I'm just making sure I know what I'm doing. Okay. So, hi, everyone. I wish I were not following that presentation. I mean, I think what I have to say sort of builds on that in a concrete way, but in any event, I'm speaking today on behalf of the Public Legal Education Association of Canada, which is an association of independent, not-for-profit public legal education providers from across Canada. And I'd like to talk about a small research project that colleagues and I conducted last spring, carried out under the auspices of CLEO, Community Legal Education Ontario. CLEO is, of course, a member of PLEAC. So over the last few years, oops, just a sec. Yeah, what am I doing here? Okay. It goes quickly, doesn't it? Okay. Over the last few years, I've worked with David Weissman, as you heard, a professor of law at U of Ottawa, to explore the role of community workers in helping people access justice. Our research drew on earlier work commissioned by the Law Foundation of Ontario that confirmed that many people in Canada who face a law-related problem turn for help to organizations in their communities that they know and trust. So last spring, we prepared a short report funded by the Department of Justice Canada. The DOJ expects to release it in mid-November, and I can send the links to you if you're interested. The report had a specific goal to help build an understanding of this community-based justice help by providing concrete examples. So, hold on, 1, 2, yeah, it's skipping. So this report, in the what we call a snapshot report, we very briefly describe 30 non-legal community-based organizations from across the country that help people who come to them with an issue that may involve the law in some way. These community workers are sometimes called trusted intermediaries here in Canada, and we call this form of help, David and I call it community justice help. We focused on frontline community-based organizations that provide one-on-one assistance to community members. We did not include programs that are staffed by lawyers, licensed paralegals, or students supervised by legal professionals, not because they aren't critical to access to justice, because of course they are, but because they were beyond the scope of this project. In our report, we aim to include a diverse sample of not-for-profit organizations. The report includes organizations from all provinces and territories serving a range of communities and in more than 8 sectors of community work, including housing help, settlement, workers' rights, Indigenous serving, intimate partner violence, and health-related. And as the time frame for the project was very short, we had to rely on publicly available information that we obtained through an online search. Okay. Okay, so some examples. So the report offers, as I said, only a tiny sampling of the thousands of community-based organizations across the country that provide some form of community justice help. And so without being able to, refer you to the published report, it's difficult to summarize. I put up on this slide 5 organizations that we included that give some support relating to intimate partner violence. So the Archway Society for Domestic Peace in Vernon, BC, the Beauséjour Family Crisis Resource Center in Shadiac, New Brunswick, the Kataujak Society Rankin Inlet, the PEI Family Violence Prevention Centers in 4 PEI locations, and the YWCA Agvik in Iqaluit, none of it. But there are 25 other organizations described in the report. The services provided by the 30 organizations we describe are not easily or consistently framed. They may be described by the organizations that provide them as community services, social services, health services, or settlement services, but not as legal services because they are not provided by licensed legal professionals. Still, as we know and as we have heard, the law is often interwoven into problems relating to housing, income support, settlement in Canada, indigeneity, and decent work. And as others' research has shown, people's life-affecting problems are usually multi-dimensional, and people who experience disadvantage often have cascading problems. A woman experiencing intimate partner violence may need to come up with a safety plan, find housing, and seek income support, for example. A legal issue is often but one element of a set of overlapping problems. Someone in the midst of a problem may want to find the best way through, but is not necessarily seeking a legal solution for the legal part of the problem. And Rebecca's research discusses this in some detail. In terms of law-related help, services provided by the organizations we describe range from giving information and referrals to supporting clients in navigating processes and systems, to helping clients understand and complete forms and documents, to helping people prepare for court, to accompanying people to legal appointments or court. Most organizations offer several of these types of services. They provide multi-dimensional help responsive to clients' multi-dimensional needs and goals. So this tiny sampling led us to several observations. The importance of the provision of holistic or wraparound services cannot be overstated. Many, if not most, of the organizations described in our report provide help in several areas, even though they may specialize in one or two. Most, for example, offer some housing support as well as help accessing income assistance or other benefits. And as part of their holistic services where clients need additional or different assistance, community-based organizations play a liaison role. They are familiar with the range of community services that are available to people and are able to connect clients with housing, healthcare, shelters, and other community services, as well as to legal aid and other accessible legal professionals. Another observation, although our online research limited our ability to delve into the internal operations of organizations, we did take note of their governance and staffing structures, funder accountabilities, and participation in voluntary standards programs and accreditation regimes to the extent they were mentioned on their websites. All measures that support the delivery of high quality services. Finally, we noticed the importance of knowledge sharing and support that comes from working in partnership and participating in associations and networks such as the Ontario Federation of Indigenous Friendship Centres, the Canadian Council for Refugees, there's a million more. So they support and mentor each other. There are also, of course, community-based legal organizations that train, mentor, and create resources for non-legal community partners. And PLEAC, the association I'm speaking on behalf of today, is composed of many public legal education providers that, as part of their mandate, share their expertise with organizations in their community. So this work I've been talking about today is part of the ecosystem of informal justice work that is carried out across the world. The global movement to support customary and informal justice is gaining momentum, and there's a report that I provide a link to on my last slide. Yet our discussions in the access to justice sector remain focused on improving people's experiences with the formal justice system, even though most people with law-related problems don't engage with those formal elements. So how can we move forward to a broader conception of the justice ecosystem to include help and support provided by non-legal community organizations? A practical step forward, although seemingly difficult in some places, would see legal regulators clarifying that they will not bring claims of unauthorized practice of law against not-for-profits absent exceptional circumstances. The rules in BC and a couple of other provinces reflect such an approach. And more proactive support could be provided to organizations and sectors providing community justice help. For example, funding opportunities could be created for community organizations to develop voluntary standards programs to develop training for research and pilot initiatives and for other collaboration and partnership work, including with legal experts. Perhaps a national working group to explore what support across the country might look like and how to get it off the ground could help advance this area of work. So on that hopeful note, let me say thank you for listening and look forward to your questions.
Thank you so much to all of our presenters. While I felt a little badly being the rigid timekeeper, now it gives us this lovely opportunity to have discussions. And I'm sure that in addition to the unique questions about each presentation that you might have, you probably too noticed so many areas of connection amongst these different pieces of work. So what we're going to ask you to do, you'll see that there's a microphone up here. We want you to have your chance in the spotlight as well. So actually, we want to be able to be sure that the folks who are joining us remotely can also hear the questions. So we're going to ask you to pop over here if you can and just share your question with whoever it is that you'd like to chat with. There's a...
Thank you. So my question's for the panel. Julie is going to know what the question is. She referred to it just briefly. So with unauthorized legal clinics in the nonprofit sector, crossing that fine line between information and advice, and the regulator possibly stepping in and creating an issue. I asked the panel, Julie doesn't need to answer because we know the question. Do you have that same problem, or have you been able to operate without that stick?
That's a great question. I'm sure everyone has some thoughts on that. It should be.
Okay.
Yeah.
Well, I guess I would say it's a problem for us doing this navigators work because I err so far on the side of making sure you're not giving legal advice that it hinders what our students can do with community members, because I have a lot of trepidation that our bar might take issue if we don't go far on the side of not giving legal advice, because I mean, people who have worked in this space longer know, like it's a real, and Rebecca was speaking this, it's just a real hindrance to giving services, especially in something like the expungement. It's not complex if you're trained, right? But if it's not your area, if you're not used to dealing with legal vocabulary and processes and systems, it's challenging. And our undergrads could certainly be trained to do it, but there's like such a limitation with that unauthorized practice of law piece that we still have to have the JDs and the pro bono attorneys involved in the whole process. So it's a pretty significant hindrance.
Look, coming also from a student law clinic perspective, it is. Look, I've never faced the problem of someone accusing us of doing something wrong, but probably like Rebecca, we err on the side of caution. And I suspect, certainly compared to the US and my understanding of the US, we have a more conservative approach to what students can do, even JD students. So, and I would say that of my partner organisations that I work with, community legal centres, they take an even more conservative view because they are, mindful of their own liability, which is sometimes frustrating for me, trying to design sort of learning opportunities for students. So, I think it inhibits at a number of different levels. But, in some ways we're all concerned about something that I certainly haven't, it hasn't, eventuated.
So when I was writing a paper a few years ago, I was trying to figure out what the unauthorized practice of law was. There's a 300-page book about how not to do it. And a lot of the training that advocates who are not licensed attorneys receive is about how not to do anything. And there's a way in which all of their points are I agree with all of them, but it's not just that it's foolish and challenging to figure out what's information and what's advice, but what you're also hearing is that these prohibitions are chilling the ability of people to do things and the ability of people to understand their own laws. And when we think about why maybe these innovations are more acceptable when nonprofit providers do them, because that's certainly the case in the United States, it's because no one's making any money off of giving free services. When you see jurisdictions that start to explore people being able to either charge kind of traditional straight up fees or sliding fees, then you get much more resistance to this kind of stuff, which tells you something about what's motivating the resistance, or at least it tells me something about what's motivating the resistance.
I don't know if you're talking about that subject, or please. I was just gonna say, sorry.
Come on up.
Yeah, where I work, we face this all the time, where's that line? And the lawyers are the ones that are very hesitant, but I think we're doing a disservice to the people that come to us, because 99% of the people who come to our office say they need something more than just legal information. So it's a little bit, I don't know where the line is, and I understand all the arguments around it, but I think it's a little bit of protectionism from our profession, and we need to be mindful of that and kind of push it as much as we can. So that's what we try to do, but don't tell anyone.
Thank you. Okay, next.
Good afternoon. My name is Aidan Johnson. I'm a commissioner of the Law Commission of Canada, and I serve as executive director at Niagara Community Legal Clinic here in Ontario. So Belinda, I'm so impressed by everything I hear about ECLC. So question inspired by your talk, but I'd be really interested to hear insights from any of the panelists. The challenges of stats gathering and recruiting community legal clinic workers as effective and enthusiastic statistics gatherers. So could you speak on that?
Yes.
And how you achieve it? Please tell me how.
I'm not sure how I can tell you how the centre that I work with achieved it. I do have Donna Askew here, who is a former director of Eastern Community Legal Centre, now is associated with Melbourne Uni Law School. I know it seems very incestuous. We didn't mean it that way. Who actually did recruit our data specialist and actually helped design the actual position description and identified the need. So I might hand over to you, Donna, if that's okay. Sure. But it wasn't easy. Yeah.
Thanks, Bea. Great question. We went on a journey at ECLC, which was a journey about creating a culture of monitoring and evaluation and understanding why you would measure what matters, and making sure that everyone from the highest parts of the organisation to the most junior in the organisation understood why it was important to be gathering data, and that was an essential and vital part of their role. And so when it came time to undertake the Enhanced Entry project, every person that was involved in every stage of those data collection journey that you saw up there, everyone had an investment in it. And I would also say that that investment was then amplified when we invested in the technology that saved those staff members time in recording that data. So I think it was a journey, but creating the culture and enabling and facilitating people to understand why you're doing it in the first place, and then they can see that connection and the outcomes for the community members was vital.
Why are they doing it? What did you tell them you were doing?
Really good question. It was, and for a number of reasons, we told them it was important to be able to show to our funders our impact. It was important to be able to show to our community members why we were doing what we were doing, and respond to those community members who are coming to us, the community leaders particularly that were coming to us saying they had these needs. So, and also that in the end, at the end of the day, that for themselves to understand their own work, to see their own work in practice, to be able to then create the digital infographics and the information that showed the outcomes of their work was really tangible.
Something that was really fascinating to me was I'm really scared of being measured, right, in terms of data and stuff. And what I noticed over the 3 years that this project has been operating is that particularly our intake and triage specialists, they may have been resistant. They didn't show us that, but they may have been resistant at the beginning. But regularly, every month, there were presentations by our data and quality specialist about the impact of their work. And as that kept going, there was just a lot of value that was shown about the work that they were doing, and then a lot of credit where credit was due to really, really show the work that they were doing at each staff meeting, and that was really great. Another thing that we've noticed as well is that the work that we've been doing in here, and we're not saying that we're the best or anything like that. It's a great sector that we work with in Victoria, Australia. Hello, colleagues. That this work has also, been something that has had a lot of interest from our colleagues in the community legal sector, particularly in Victoria, but also nationally as well. And we're so happy to share our learnings and also our failings when they haven't worked. And I think that that has helped shift gone a little way and maybe shifting some attitudes maybe across the sector. Thank you, Aidan, for the question.
Really interesting. Just as we're waiting for the next person to come on up, I want to mention folks who are joining us via Zoom that we do have somebody monitoring. So a colleague can bring your question up to the mic if you have one.
Thank you. My name's Tina Rothstein. I come from the United States. I think this is a follow-up to the last question, then I also have a question for Becky. So you didn't actually we didn't have time to talk about the technologies that you're using for data analysis. But my ears did prick up when you said sentiment analysis, and I don't know how much you are using large language models and other types of technologies, and wondering in that context how you are explaining to clients that you're using their data for those purposes, how you're dealing with privacy issues, how you're dealing with the issue of data being sent to outside of the organizations and questions like that. If those are the technologies, and I should say I'm a big data, let's find out what's going on in the world, but of course all those technologies bring very serious risks, and so I wondered how you address them.
Absolutely.
And then after that I have a quick question, or not a quick question for Becky, but a question for Becky, but I'll let other people ask.
I'm going to hand back to Donna to explain the technology for this one.
Here.
She's just more articulate than me, we've just got to be honest.
Oh, no. It's a great question, and there was lots of parts of it, so I'll try and do justice to it. So in terms of the technology we're using a contact centre platform, a digital contact centre platform, which gathers the data for us. We're also using Power BI to be able to collate different streams of data. In terms of the privacy question, as part of our enhanced intake process, we let people know that that information is being collected, and if they have any concerns, they can raise that with the intake worker. What was the other part?
Well, so I don't know, you said sentiment analysis, and I don't know if you're using new forms of
question.
But that involves actually sending a lot of data outside of the organization.
Yes.
I wanted to hear how you're addressing this.
So sentiment analysis is very new. It's built into the contact centre technology. I understand that there's some AI that sits behind that, that's helping that. We are very, very, it is at the very start of that. So we haven't gotten into it too far. In terms of how we're managing that information that's going externally, I was just going to check with B in terms of, we know that that information is held within that contact centre system. In terms of how that goes externally, we haven't had it come up as an issue yet.
Yes, that's right. Not that we're aware of. And we obviously get rid of the information after a period of time as well.
Yeah, so there's systems and processes that purge that data if we weren't to have consent, but just generally the systems are set up to I guess, manage the risk as best as we can.
But we're constantly monitoring it because other risks will come up.
I know
Hi, my name is Michelle. I kind of come from the community side of things. I work for nonprofits, and now I am at a firm that works with complex institutions wanting to address upscale justice pieces. And my background is in restorative justice, conflict transformation pieces. And I was really excited Julie and Rebecca, just the work you're talking about and how you included community organizations that aren't just necessarily navigating and pointing to legal services, but also expansive understandings of justice and the upstream and the social justice kind of pieces of that. I'm curious, my question is, what was your process of deciding to include those types of organizations that aren't necessarily directing to legal services, but kind of expansive understandings of justice? So of determining which ones, why was that important to you in this process? I'd love to know.
So for me, so you're talking about both the specific organizations and how we got into sort of looking at.
Wanting to include that type of.
Yeah, those sort of, yeah. So as executive director of CLIO, well, one of the programs at CLIO is a program that trains. We're a public legal education organization, and part of our mandate is to train community workers, non-legal community workers who assist people with their law-related problems. So we have a program called CLIO Connect, and they go out in the community and they respond to requests all over the place for training in various areas. And it became apparent through all the trainings we conduct that so many community workers were providing really important, vital assistance beyond just simple referrals. Sometimes referrals aren't so simple, but beyond just good referrals, are really sort of providing support, particularly in areas they know, but they want some more legal expertise. So that's how I started first. I did a fellowship with David, but I sort of first got into that because just my awareness over the years at CLIO, even though I wasn't running the programs, we had others doing that, was just, wow, this is a huge source of assistance, of really important assistance for people. That's where people are going. Right. And then in terms of this little research project, because it was on a short time frame, I talked to all of the PLEAC, the members of the Public Legal Education Association Canada, about what organizations they knew in their community who were providing sort of fulsome support. We reviewed all the list of the Department of Justice Canada projects that sort of they have funded that are the non-legal organizations providing law-related support, and we drew from those to get sort of, I wouldn't call it a representative sample, but a scattering of diverse organizations across the country.
So I think that one important source for us was looking at the 20 years of civil legal needs surveys that now exist in lots of different jurisdictions. And one of the questions they ask you is, okay, so you're 3 months behind on your rent, or your employer's not paying you overtime, so you don't have to know it's legal, you just have to know you have the problem. Then what did you do about this problem? Where did you go? And in almost every jurisdiction where this has been studied, law is like the last place. So people are seeking assistance from religious organizations, community organizations, their neighbors, and so on. I was really struck. I was doing some interviews in a community where I had done a survey, and I was following up on people's experiences. And it was meeting with this family that was having a courthouse auction of their house because they hadn't paid the taxes on it in several years, and they didn't know they hadn't got the tax bills and so on. And so I said, so what did you do when you got this letter that made no sense? And they said, I went to the Department of Motor Vehicles. and the DMV was really helpful. So there was somebody there who the community knew was a person who could problem solve for you, even though it was a completely formally irrelevant institution to solve the problem. And that's how people actually do this. And so, yes, absolutely. And so if you're trying to assist people in resolving issues, it makes much more sense, instead of trying to change, in my country it would be 330 million people and the way they act, to think about what they're already doing and embed resources and opportunities there.
I'm going to offer both a problem and an interesting turnabout as a result of the problem. So the problem we had was initially a good problem. The Chief Justice of our Pennsylvania Supreme Court in Pennsylvania, I'm in Pennsylvania, wanted to have every single law school in Pennsylvania have an elder law clinic. She was determined to get legal services for older adults. That was her mission. Well, not too surprisingly, law schools, as much as they believed in that mission, pushed back because they already had clinics, and clinics are expensive to operate. And it was about a 2-year process of us educating her about how much it costs, which clinic would you like to get rid of in order to have the elder law clinic, the one that serves children or the one that serves disabled people, that type of thing. But eventually they understood. But what came out of that was all of the law schools agreed to create an elder justice consortium whereby we are, as the law schools, we call ourselves the Pennsylvania Law Schools Elder Justice Consortium. It's actually nothing other than a collective group. We meet about every other month. We share problems. We share potential resources. It means that we now know what each other's schools are doing. It's been a very positive dynamic, and I think it's going to go somewhere. We're now working on how could we do amicus briefs as a consortium. Do we have to create a formal enterprise?
So interesting. Wow. Okay, I think we do have a question from one of our online colleagues.
Yes, we do. Thank you. There's a question online for Abir Mirza. Children are amongst those most at risk of facing obstacles which prevent them from accessing justice and upholding their rights. How do legal clinics assist children and address barriers to justice faced by vulnerable children from marginalized communities?
I'll start with the Australian example, maybe. The Victorian example. So, and thank you for the question very much. In Victoria, Australia, there are what we call generalist community legal centres and specialist community legal centres. So the generalist community legal centres are like the ones that Donna and I come from, where we provide services to people who live, work or study within a certain geographic region. And then there are the specialist community legal centres where they provide services on specific areas of law or to specific, communities. And so in Victoria, we have a specialist community legal centre that is specifically for children and young people and their legal issues. But also the generalist community legal centres also provide legal advice to children, provided they are able to, give us instructions. And so we take instructions from children who are as young as 10, and at the centre that we work at, we haven't had a 10-year-old come to us, but we've definitely had 12 and 13-year-olds come to us. In terms of under 10, at least the laws in Victoria and Australia are that, firstly, that children aren't able to provide, aren't necessarily able to provide instructions. However, if their parents come in, then we can accept instructions from them. Would that be right? Yeah.
Thank you.
Did anyone else want to contribute? If Mary Birdsall was here, she could tell us about the Justice for Children and Youth, which is a clinic for youth in the Toronto area, which does some really fantastic work. Yeah.
Quick point of information. I was trying to find it. Doesn't Ontario have a safe harbor around unauthorized practice of law issues when it's nonprofits who are helping you? And I saw a report from this maybe 3 or 4 years ago. I'm sorry, my Canadian. So my Canadian geography is back on par with my U.S. geography. Both terrible. But I saw a report there was some province that had a. Does that not ring a bell with anyone?
Yeah, so British Columbia does, and a couple of other provinces do, And that's what I was sort of suggesting there. Yeah,
Okay.
yeah.
Hi, thanks for a fascinating panel. A lot of my questions already got asked, thank goodness. I just wanted to then lob a question to Rebecca in terms of your framing around access to justice work as democracy work. And I guess the question that comes to, I'm David Wiseman, professor at University of Ottawa. Question that comes to mind is who the audience is for making this connection. I mean, you've convinced me about the importance of the connection, and you've talked about engaging regulators and etc. We can look here, we can also look to the US, we can look to other countries, and democracy is maybe not having a great moment. So how does attaching the importance of access to justice work to democracy work how is that going to resonate in a way that's going to help advance, or why do you think it might be helpful to attach those things in that way, given the democratic moment we're in?
I'm going to start an answer, and I'm going to invite Matthew to improve it. I think there are a range of, this is like a law review article, right? So I'm not anticipating that everyone under their Christmas tree will pull out this and read it to their children. So it's partly trying to beat back rule of law orthodoxy with people-centered access to justice orthodoxy, right? And to show that there's something much more democratically encouraging about a people-centered approach. It's a way of also, I think from my perspective, strategically citing ways that people can use law outside states that are in danger of not working so well, so that there's some vitality in civil society to push back on those states which may go in bad directions in a couple of weeks. So I think in that sense, there are also, who reads law review articles? Law professors, no offense, but, but there are international organizations that try to set norms. There are funders who give money for different kinds of justice activities, who it would be valuable to convince that they should fund differently. There are funders who are not funding justice activities, but care a lot about democracy, who might think differently about how they would make investments.
Nothing to add?
I would say one other audience is the legal profession, right? The legal profession often sees itself as an independent profession in order to be a check on government, but it doesn't often see itself as part of the problem of estranging the public from its own law. And so I think part of that is making that connection and seeing the ways in which the professionalization and monopolization of law has created challenges to access and opportunity and participation in democracy.
Thank you. I think we have time for a couple more questions. Do we have one more online? And then I think we've got another
Just
individual.
following the questions, okay? So I don't have any big introduction to this. Just on a second follow-up question for Abir Mirza, how do you address challenges on data collection with working with vulnerable children accessing law?
That's a really, really hard question. I'm just trying to think about, in the time that we have been operating the Enhanced Entry and Triage project, I'm sorry to say this, Abir, I don't actually think that we have had, at least they haven't come to my attention, callers that have been at least under 17, if not under 18. So in terms of collecting data from children and young people, that's not something that we have at this stage dealt with. I would say though that, we as an organisation that is transparent and accountable for public funds, we would be, of course, adhering to the privacy principles that we must adhere to in Victoria, and that's the information privacy principles and the Australian privacy principles, which would continue and apply to children and young people as well. This question has made me think out loud, so apologies everybody for hearing the thoughts going in there. It does make us really think though about what we do have to consider in terms of when that situation arises. So I really want to thank Abir for that question.
Thank you. Okay, I think we've got one final question to close us out.
Good to be final too, because I just think it's been a fabulous panel, all of you, just really, and Rebecca, the lovely connections between democracy, and it's been a really great, excellent panel. It's more a point of information, and I think particularly Julie and Becky might be interested in this. I'm evaluation advisor for Law for Life UK, and they do a lot of training of trusted intermediaries, and they, the UK has issues around authorised, unauthorised, which don't actually, sadly, apply so much in Australia, which means it's, as you probably know, freer for non-legal support for clients. But I just wanted to, and to others in the room, to point you to Law for Life's website. Lita Wintersteiger is an amazing woman who runs the organisation, and it's got amazing tools and website information around advice now is the sort of time and place thing. But for those of you interested in working with trusted intermediaries, it's a public website. It's got amazing toolkits and all sorts of things, particularly for working with vulnerable communities, which is their priority target area. So it's a really good website, really good information, and Lisa Wintersteiger is amazing to work with. So across those international boundaries, if you're interested in public legal education and training people who are the most likely people, as Becky said, people to turn to for help. So thank you.
No, thank you. And just wonder if our panel members have any final thoughts, any interesting thoughts that you had about connections within and amongst your presentations, or have we talked you all out? Looks like maybe we've talked you all out. So thank you to the panel. Thank you to everybody.